Chair, if I can then take your assumption back, if I may, and Lord Sandhurst as well, to what you were saying about international obligations and what the UNHCR had stated, which was cited by my colleague Lady Mayor in her earlier question. You just said to us, Lord Sumption, that Rwanda would not accept the bill or these procedures that are in the treaty if it thought it was in breach of its international obligations, if they thought that international law was being breached. And I think you were quoting the Prime Minister as well, who has said much the same thing. So when we have the UNHCR saying, and again I quote, only as recently as last week, UNHCR has not observed changes in the practices of asylum adjudication that would overcome the concerns set out in its 2022 analysis and in the detailed evidence presented to the Supreme Court. And then also, the UNHCR has concluded that excluding asylum seekers from some of the protections within the Human Rights Act, and I quote, undermines the universality of human rights, has implications for the rule of law, both domestically and internationally, and sets an acutely troubling precedent. And I wondered if you agree with that analysis, or if you think it's based purely on political considerations, or whether there are legal arguments there that we need to understand.
I do not agree with all of it. When I say I don't agree, it's really a question of relevance more than anything else. Their point about the importance of having judicial adjudications seems to me to be satisfactorily met by the fact that it does not make any difference to the way that the deportees will be treated, whether they apply for asylum or whether they get it if they do apply. Now, the concern of the UNHCR is much wider than with international law properly so called. What they are concerned with, possibly above all, but certainly among other things, is the orderly functioning of the international system for asylum and for dealing with very large numbers of refugees displaced by natural catastrophes, civil wars, and so on. That is a perfectly legitimate concern for them to have, but their concern is with the orderly functioning of this system, and not only with questions of international law properly so called. Basically, it is animated by a view that the UNHCR has taken for a long time, that measures like this effectively are beggar my neighbour measures. They pass the parcel measures which have the result that an unfair proportion of the burden is lumbered on other countries who may not be in a position to take the same measures or may not wish to. Now, that is an important point. I don't wish to devalue it in any way, but it is not a point based on international law. It is essentially a judgment based on the orderly administration of a very complex system of international treatment of refugees.
That's a really helpful answer, and I'm grateful to you. It seems to me, and it was a point made in our debates on Monday in the House, that outsourcing can very easily become offloading, passing responsibilities to others in the way you've just described. What you also point to, though, in a world where there are 110 million displaced people, according to the UNHCR, a growing number, it's 20 million more than it was just 2 years ago. In those circumstances, does international law need to be revisited, and how could it be best revisited? What can we do about updating it in the ways that I think Lord Sandhurst was suggesting earlier on need to be done? But it's true that many of these treaties and obligations were entered into a long time ago, though there was massive upheaval in Europe at the time. So we've been here to some extent before. But what would your wise counsel, your advice be about what would need to be done at an international level?
I think it's always going to be extremely difficult to modify a treaty to which I think on the latest count something like 160 countries are party. It's one thing to devise such a treaty initially with a small number of countries, and it gradually expands as states come into existence with decolonization and so on. It's a quite different thing to take an existing system and modify it. But there is another problem about that too, which is that there are there would be two kinds of amendments that people would want. Many people take the view, I'm not expressing my own view at all, that there is a strong current of opinion which suggests that relative ease of travelling, the availability of large people smuggling gangs, and other developments have made mass movements to other countries a great deal easier than was the case in 1951. And that the sheer scale of the problem, combined with the relative ease of moving across the globe, means that the whole principle underlying the Refugee Convention needs to be changed. Other people take the view, right on the opposite end of the spectrum, that the Refugee Convention ought to create obligations to accept refugees, which currently it doesn't do. It governs the treatment of refugees when they're here, but not whether we have to accept them, and would wish to strengthen the protection of refugees under a revised treaty. The problem of reopening the whole issue of the terms is that you're never going to get agreement between these extremes, and I think a lot of people feel that if they reopen it for the purpose of strengthening the protection of refugees, they may end up with governments actually very much narrowing the protection of refugees because of the first of the two considerations I mentioned.
Thank you very much.
Absolutely. That's
so beautifully summarised.
Yes.
Very grateful to you for that.